Last day of Startup Boston Week 2024. I hope you all have been having a great time so far if you've been attending other sessions throughout the week. This is the 8th annual Startup Boston Week. My name is Emily Rogers and I will be your host today. First and foremost, I want to offer a huge thank you to Suffolk University for hosting us. It literally could not be possible without the tremendous work of Suffolk Sawyer Business School. They've hosted now for the second year and have been an absolutely amazing partner. They host a lot of great opportunities for learning, both in and outside of these classrooms that we're sitting in today. And we really appreciate their partnership for year in and year out. The goal behind Startup Boston Week is to connect the entire greater Boston and New England startup community. So you'll see folks from all industries, from all departments, all bootstrapped levels of funding, and from all different areas of New England, all come together for 5 days of learning and connecting with one another. Hopefully you've made some great connections while you've been here and continue to make many more throughout the day. The team that creates Startup Boston Week is primarily volunteer, and the folks working the conference today are volunteering their time as well. So please give them a good smile and a big thank you if you catch up with them. Thank you so much for attending. This conference is a labor of love, and we appreciate all of you playing your part in it. So without any further ado, I'd like to welcome Chris and Patrick, and we'll get kicked off for the morning.
Great, thanks, Emily. So in terms of presentation format, this is obviously a pretty intimate group. Chris and I aren't married to any slides. Please feel free to raise your hand, jump in with a question at any point. I think there are live mics so that folks who are joining us virtually can hear. So if you do have a question, just wait for the live mic to come around so that everyone can hear you.
Yeah. There's one thing that I don't like doing when I do these presentations is being a lecturer. So when I say participation is welcome, it really is welcome. So we really want this to be a conversation, and the slides are going to be here to sort of guide the conversation. But if you have questions as we go along, don't feel like you have to wait till the end. We can talk about things.
And they are kicking us out promptly at 10 a.m. And this is really a topic that we could spend days or weeks talking about. So we're going to try to move pretty quickly to allow folks to ask any particular questions you have. So just super brief introduction. Chris and I are both partners at Foley Hoag. I co-chair the Emerging Companies and Venture Capital practice, which, as the name implies, involves a lot of venture capital deals and emerging companies through a full life cycle representation, which involves working with all of our subject matter experts, whether it be IP or employment.
Yeah, my name's Chris Feudo. I'm a partner. Patrick and I have worked together since we were baby associates, and now we're partners together. I'm the co-chair of the labor and employment practice. So Patrick and I work together quite frequently. My practice is, the bulk of my practice is employment counseling, employment litigation. So when I work with Patrick and the firm's clients that are in the ECVC space, it's a lot of the times it's advising them on getting set up as a business, and part of the big part of that is as you're starting, thinking about the topics we're going to talk about today, which is as you're forming the business, what are your obligations to your employer, as to other entities, your employer or other entities you've been working with previously. How do you get protections into place, all that? But we'll talk about the agenda.
Yeah, so we, like Chris said, we're going to have, the way I'm thinking about this is sort of in 3 different stages of a life cycle. As you're conceiving of a new venture, you need to be thinking about yourself and your obligations to your current employers and any past employers in relation to their trade secrets or any restrictive covenants where you've promised to do certain things and not do other things vis-a-vis those current or former employers. Then once you've taken care of all of that housekeeping and have actually started your venture, obviously you're going to need people around you to help. So you're thinking about hiring employees and consultants and advisors, and you need to be mindful of making sure that those folks are taking care of their own obligations to their current and former employers, and also agreeing with your new entity to treat your confidential information confidentially and assign intellectual property to your new entity, and to do certain things and not do other things, either during the course of their employment with you or afterwards. And then the third sort of point in the timeline or life cycle that we're thinking about is, what do you do when folks leave? I mean, obviously we don't have, indentured servitude here. People move from job to job. How do you make sure that when people are leaving the business that you've started, they're not leaving with your secret sauce or unlawfully poaching your employees, et cetera? So,
Yeah,
go ahead.
you want to take this? So, there are a couple of sources of obligations here. I mean, so there are sources in the law that have, impose obligations on individuals. Like, you can't, a lot of states have obligations that say you can't have statutes that say you can't misappropriate trade secrets. But otherwise, most of the obligations that that employees have to their employers, or consultants have to the organizations the entities that they're consulting for, are going to be contractual. And if they violate those agreements, they're going to be in breach of contract. So that's generally the threat of potential legal liability. So when we talk about employment agreements and what the sources of those contractual obligations are, there are generally 4 types of agreements that we are concerned about at these stages that we're going to talk about. One is a confidentiality agreement or non-disclosure agreement. Basically, these types of agreements say you agree that you're going to be exposed to confidential information, non-public information, and you agree that after you leave employment, you're not going to, while you're employed, you're not going to use or disclose this outside of the course of your employment, and that after you leave, you're not going to use and disclose this confidential or proprietary information to third parties. The second type of agreement you commonly see employers require employees to sign are invention assignment agreements. That basically says anything that you create while you're employed for the company, by the company, is the property of the company. And that you agree that you will assign your intellectual property rights to the company over that work product. There are carve-outs for that typically. The law, particularly in some states, have California being one prominent one, basically says you can't be required to employers can't require employees to assign things that they do entirely in their own time without using company resources or company intellectual property, and that it doesn't relate in anything to the company's business. So there are exceptions, and there are sometimes state law can be helpful there. The third and fourth types are non-competes and non-solicitation agreements. Non-competes are exactly what they sound like. You agree that for a period of time after your employment with this employer ends, you will not compete against the company. The language of these agreements can vary in a lot of ways. It can be you agree that you won't work for a competing business, or you agree that you won't do the same type of thing for a business that competes. these are very heavily regulated. And so these are a source of a lot of dispute when an employee leaves. A lot of employees will, there are a lot of disputes between employers and employees about whether the agreements they sign are enforceable or not, just because that there are so many laws now, particularly being passed to limit non-competes, because there's a general recognition, I think, that a lot of employers have used non-competes in a way that has been overly onerous to employees, and so states have taken action against those. Non-solicits typically come in two forms. One is an employee non-solicit, which is you agree for a certain period of time after your employment ends that you will not try and take away employees of the company to go and work for another company. Customer non-solicits are different. Customer non-solicits are, you won't try and solicit or take away or divert customers or business away from your former employer on behalf of a new entity. Those are generally enforceable, and they are less regulated.
Question.
Yeah, so you mentioned about using company's resource. We work with the company's laptop, for example.
Mm-hmm.
Can they claim that because you're using the company's laptop, you're using the resource to develop our own business? If you're working on our own business and it overlaps the laptop that you use, for example. So you mentioned that a company can claim that using the resource would be, if you use the resource, that they could be saying that they own the idea. And when we work with the company's laptop, we may we use the laptop in our extra time to do our own thing. Could they use that as can they exploit this? Yeah.
Right.
I think the answer is yes. It's a fact-intensive inquiry, right? So you never know. Every case is going to depend on the facts of the case. It's also going to depend on what the intellectual property you're creating is, and the times in which you're doing it. But my recommendation to somebody who is inventing their own business, who's going out there and trying to create their own business on the side, would be to keep as much of that as separate as possible. So if you should not be using company equipment to be doing that.
Or networks, right? You have no expectation of privacy or ownership when you're using your company's network generally.
Right.
So coming back to our rubric of I'm working for Amazon and I want to start my own company, right? That's sort of the first point in the timeline that we're talking about here. Sort of what not to do would be to, duck out for your lunch break at noon using your Amazon issued laptop to start writing your business plan, which involves, Amazon does a lot of things. So
everything under the sun, right?
I chose a very bad example, but to start making a list of your coworkers who would be great co-founders for your enterprise, right? So in that first part of the timeline where you're thinking about jumping ship to start your own venture, like Chris says, you need to practice really good hygiene. And the first part of that is going to be reading your contract, right? I promise you that if you're working for any sort of a sophisticated business, you will have received probably an offer letter that has either a employee restrictive covenant agreement stapled to it, or a proprietary information and invention assignment agreement, or employee NDA. These are all the same contract basically, but they go by different names. All of those contracts will have the 3 or 4 prongs in them that Chris just outlined. And some employers are more aggressive than others when it comes to, we see some really aggressive ones. The ones that, Foley creates for very early stage companies tend to be, assertive, but middle of the road. But in the contracts that I draft for employers, the expectation is that you're only working for the employer. Anything you create, usually we say, in relation to the company's, in relation to your employment or arising out of confidential information, et cetera, belongs to the company the minute you think of it. and it's automatically assigned, and we'll get to that. And beyond that, during the course of your employment, you're not going to compete. And Chris mentioned any post-employment covenants not to compete are heavily regulated by state law, de facto unenforceable in California, a little tricky to enforce in Massachusetts, et cetera. But so the short answer to your question is yes. And we have a question in the front.
Mm-hmm.
Oh, thank you. Again, I have a...
Oh, wait for the mic. Sorry.
Mhm.
I keep forgetting.
Good morning. Thanks. I'm Fabian, founder of a startup in the biotech field, and I have a question that actually is connected somehow. In his example, it was already in a company, right, where he initially signed the contract. He's employed, and he tried to work toward another business he can create. In my situation, I already started and founded this small startup, and I've been proposed to work at a side job in another company. So my question is along the same lines. If there's a contract that could be generated, is it possible, acceptable, or commonly practiced to basically modify accordingly the contract so that any ownership of IP that might arise on my hand, right, independent from the work in this company, is still mine or my startup,
Yes.
property? And in terms of non-compete as well, is there any way to make sure I can protect somehow this company from additional work done in the other company?
Yep, understand.
Yes.
Yeah.
Regularly, I'm asked to, it's not uncommon for our clients who have startup businesses to say, well, I'm taking on a part-time position at another company, or I'm taking on a consulting arrangement for another company. And they'll ask me to review their employment agreement or their consulting agreement with that other company. And the first thing I ask is, okay, what do we need to carve out of their agreements to say, this is yours, and they can't claim an ownership over it, interest over it? Because if you are entering into an agreement with another entity and they have a broad assignment of IP language, anything you're doing during that period of time arguably can be theirs. So it's 100% appropriate, and you should make sure that in any agreement that you sign, anything that you've been doing before that, and most agreements, if they're good agreements, will have provisions, like our fully generated forms have listed saying, hey, listen, this is the IP that we've created before this agreement that we believe should be carved out of this agreement. But if it's not in the agreement that's being provided to you, that is something that you should raise and you would want carved out.
Mm-hmm. Yeah, like Chris says, obviously here in Boston, we're in an ecosystem where there's tons of serial entrepreneurs who have multiple ventures going at once. So they're very careful to say, okay, my founder agreement with therapeutics company X relates to the field of interest of, conception, development, and commercialization of, small molecule drugs targeting, CNS diseases or whatever, right? And then the agreement will go on to say everything I create in that field of interest belongs to the company, and everything that's set forth on Exhibit A is carved out of that obligation. So then on Exhibit A, you say, okay, I know I had this oncology company that's ongoing, and I do consulting for, X, Y, and Z university and X pharma company, right? So it's all just, you have to be very careful with the confluence of contracts and just, getting ahead of this stuff and paying attention to it, rather than sort of going off and taking the risk that your employer is going to try to reach in and grab your what you feel is an unrelated piece of property.
Thanks very much. Maybe a last connected, a little more complex in the way that not only they are interested in me working for them, for their entity, but they also suggested another option I'm not really thinking of, because I'm really thinking that kind of be complex. They're asking me if I'd be willing to work for them on my own project from the startup in their biotech and use their resources to move forward my ideas But then my problem is that I was like, if I become an employee of this company, because they told me after you could maybe move on with the startup again with those findings, but I'm like, this could not happen in reality.
This is a little more complicated than, so I'll go back here. We've got QR codes here for let's follow up. I mean, this is pretty complicated stuff.
Yeah. You know, I will follow up offline.
I form biotech and pharma companies all day and help them with stuff like this.
So let's say, oh, sorry, question.
Yeah, just one quick question. This is a pretty straightforward one, but you spoke of, first of all, having the ability to look over your contract, making sure you're not overstepping any boundaries legally on that side. But if you are transitioned to creating your own venture or business, you spoke of maintaining hygiene. So once we get the legal checkbox, out of the way, I know I'm not overstepping any boundaries legally according to my contract. When we speak of hygiene, in this period of transition, what are some type of guidelines you recommend about keeping the hygiene? Because even though maybe you're not overstepping any legal boundaries, there is a social component. So, for example, if your coworkers or your managers, come across, a full-blown website that you have, that could bring maybe not legal implications if you're abiding by your contract, but it can bring a bit of an awkward, perhaps conversation or
Sure.
type of dynamic in your company. Maybe your coworkers are now asking you about something else. What are your thoughts on this?
It's an interesting question, and I think that there's not really one sort of way of advising an individual in that context, because I think the culture of the workplace is going to be a key factor in that. I think that there are some workplaces that you're going to be in where there are going to be a lot of employees who have these side gigs that they're going to be, people are constantly looking to innovate and develop ideas, and they're just entrepreneurial in nature, and it's not going to be a big deal. And so people talk about these things openly, and it's fine. But in some bigger companies where that may not be the case, and so it may not be advisable to be discussing these things out in the open, right? And it may be advisable to try and keep what you're doing on the side. I wouldn't say be secretive about it, but being discreet about it, right? Not advised, like you said, you're making sure you're within the bounds of what you're legally, what your legal obligations are. You're not doing anything that's violating your contractual obligations, but at the same time, you don't want to trip off any red flags to anybody that's going to cause anyone to look at you differently or want to maybe, not trust you within the workplace or want to exit you from the organization because they think that you are not sufficiently committed to their mission, right? And I've seen this before. I've seen employers come to me and say, we want to terminate employee X. And I say, why? And they say, well, he or she doesn't seem committed. He or she is constantly talking about his or her outside ventures, which they're legally entitled to do, but it doesn't seem like they really are focused on what we want to be doing here, and we think we need somebody more focused here. Yeah. So I think it's not legal advice, really. It's just, you have to read the room, right? And so a lot of it is having the sort of the getting a feel for what the workplace is like and what's tolerated there, and making sure that you are focused on in establishing that you are committed to your employer's mission and not letting your outside ventures distract you from your employment for your current employer.
Yeah, a lot of what we do is sort of twofold, right? There's like Chris said, you've got to read the room. So a lot of the advice we give isn't pure legal advice, like, oh, your contract says this, and under such and such case law and such statute, this is what you can do. A lot of what we do is practical sort of interpersonal and business advice, right? So once you've read your contract, and good job reading your contract and figuring out the moonlighting policy, as they call it, and what you can do with company property and how you can use the laptop and all the rest. Now you have a question of, well, okay, if I'm like Fabian, who's got a biotech startup that you're working for, but also you have a passion project that goes to reselling vintage fly fishing gear or whatever, right? Is his employer really going to care about that until as long as he's doing it on his own time, using his own resources and all the rest? The contract might say you will spend your entire business effort in furtherance of the business of this company, unless we say otherwise. Doesn't mean you can't do it, right? If you go and ask for permission, then you have permission and you can do it. But it's something that's totally divorced from what your primary business effort is, and you're not using any company resources, and it's not a big distraction, probably that's going to be okay. But as your sort of outside project starts to get closer and closer to the line of what you're doing for your employer, then you start to get in potential hot water. That makes sense?
Yeah. I think you can move.
All right. So a few of these slides just start to unpack a little bit what the terms of what those restrictive covenant agreements that you're likely subject to, or proprietary information and invention assignment agreements will have in them.
And I think this is like, we've sort of moved to the assuming that you have exited, right? And assuming that you have successfully moved past the point where you've exited, you've complied, and now you are thinking about potentially bringing on your own employees, right? And you've exited your employer, and you are thinking, okay, well, I'm now going out to my own venture. What do I need to be thinking about for myself, for my own business? I think these slides deal more with that.
So yeah, as we go through this, you can sort of mentally shift which hat you're wearing, right?
Yeah.
You're thinking about, okay, I'm the obligee under these restrictive covenant agreements and invention assignment and confidentiality obligations, meaning I need to watch what I'm doing vis-a-vis, I guess you'd be the obligor. Right?
That's what you get for using complicated language, Patrick. You just say.
I have made all these promises to my current employers. So that's one hat. The other hat that you're thinking of once you start to launch the businesses, I want everybody who comes to work for me to make these promises to my company, so that I know that my trade secrets are locked down tight, that all the output of the work that folks are doing for my business belongs to the business, et cetera. So one of those prongs of the proprietary information and invention assignment agreement is going to be confidentiality obligations. Chris touched on this earlier, but basically you have obligations, and you want to impose obligations on your new employees to treat your confidential information confidentially, not share it outside of the four walls of the business, and not use that information for the benefit of anybody other than the business. Pretty simple. This also goes to invention assignment. It's important that any contract that you're signing up with new contributors, whether they be employees, and don't get Chris started on the difference between employees and consultants and advisors. That's a whole other 2-hour-long conversation.
That's another session.
Yeah.
And you don't want to get me started, because then I get angry.
So just footnote, be careful when you're bringing in new people and you're calling them advisors and consultants when really they ought to be called employees, because the state of Massachusetts does not take kindly to that. But each of these people, whatever role they are, advisor, consultant, independent contractor, or employee, is going to have contractual provisions that says, when you're doing work for me, my new company, that's my brainchild, my baby, you need to understand that anything you're creating, the minute you write it down, it belongs to this company, not to you. And the contracts, if properly drafted, will affect that result for the benefit of the business. You want to take non-solicit?
Yeah, I'll take non-solicit. So we talked a little bit about non-solicitation provisions, but when you're the employer, what should you be thinking about in terms of your non-solicitation provisions? You want to prohibit employees from soliciting employees from your customers or your employees for a period of time. Typically, that's usually a year. That's usually considered reasonable. I've had employers come to me and say, we want to prevent them from doing that for like 4 or 5 years. And I say, yeah, there's no court's going to enforce that. But a year is considered presumptively reasonable generally by most state courts. Generally, you want to specify the scope of solicitation in the agreements, right? Like what exactly you're prohibited from doing. So I have reviewed agreements or I've been asked to draft agreements where the non-solicitation provision has basically been turned into a no hire agreement. Basically, you agree that you're never going to hire anybody who worked for the company or you're never going to do business with anyone who did business with the company. That raises real concerns because that's not a non-solicit. That's a restriction on trade, which could potentially raise antitrust issues. Right? So solicitation is you going out and trying to recruit an employee or recruit a customer or try to divert a customer away from your former employer. But if a former employer leaves their employment, leaves their employment and comes to you and says, I want to come work for you, and they don't have a non-compete, it's hard to make an argument why a non-solicitation provision should prevent an employee or a former employee from hiring that person. Similarly, if a former employer isn't actively seeking to divert away your customers, it's a very hard argument to make that you have a legitimate business interest to prevent your customer of its own volition from going out through no act of your former employee going out and going to do business with another company. So I think you want to make sure you have a reasonable scope within those non-solicitation provisions to really focus on solicitation to ensure that they're enforceable. You want to avoid ambiguous language. You want to make sure you're very clear about the conduct you're prohibiting. You want to have it be a reasonable period of time, as I mentioned, and it really is. It is a mechanism to prevent use of trade secrets and confidential information where you are concerned that you have an individual who may not abide by their non-disclosure agreement, right? I have clients call me up all the time and say, I want a non-compete or I want a non-solicit on this person. And I say, okay, why? And what's the need? Do you really care if they go out and compete or solicit? And they say, no, but they have confidential information. And I said, well, you have a non-disclosure provision. They said, yeah, but they're not going to abide by it. I say, oh, okay. Well, if you know that person's not going to abide by it, then maybe if you have it, then you want to have some additional protection. So, it's another way of doing that.
Yeah. So for example, let's say we have a skincare products client, right, who has a big Rolodex of customers and a sales force, right? Mm-hmm. It's important for the company to bind, I suppose, people to non-solicitation provisions so that they don't go to work for potentially competing business and just take the company's list of clients which is a trade secret, right? A client contact list.
Could be.
Yeah. If you're right. We get into some real nitty gritty trade secret stuff here in a minute, but imagine a world where the VP of sales could just walk out the door and start calling contacts that he or she got by virtue of having worked for your company to say, hey, that skincare line sucks. Like, you should check this one out. Right. So this stuff happens in real life, and we get involved in, big high dollar litigations, over it. So the only other thing, Chris, you mentioned, defining the scope of the behavior. One common exception that might be worth noting is that usually in these non-solicitation provisions, it will say you won't recruit, you won't try to poach, is the sort of colloquial term. You won't try to poach our employees for a period of 1 year. But usually there's a carve out for sort of, general, a new employer's general, putting an ad in the newspaper or whatever. People can move around. It's, people are free to move and choose their own jobs and so forth. And that can't be prevented by a bilateral contract.
Yeah. And some state laws actually have started to regulate non-solicitation provisions like they do in that way, and saying you can't prevent somebody from, like, you can't prevent a non-solicitation, can't prevent somebody from applying for a job of their own volition.
Good segue to non-competes, which I think states are starting to regulate non-solicits a little more like non-competes in some ways, right?
Yeah, non-competes are heavily regulated. So if you want to have a non-compete in your with your employees, the number one rule I have for you is consult with counsel about enforceability under applicable law before you put a non-compete provision in any agreement that you have with an employee. This is important not only because now it may not be enforceable, but under some state laws, if you impose an unenforceable non-compete against an employee, that is its own violation of law. Like, you are committing an independent violation of the law, which you could be held, there could be consequences for you. So you want to be careful of that. State law varies on this so much, so it's hard to generalize on what non-competes need to look like. As Patrick mentioned earlier, California, no non-competes, no non-solicits. We talked about non-solicits as well. There's a debate about employee non-solicits, but most recent cases on that are no employee non-solicits either. Massachusetts, in 2018, passed a very, very strict non-compete statute that basically says if you want to have a non-compete with an employee, you have to jump over all of these procedural hurdles. And you also have to pay the person garden leave, which is defined as 50% of their salary for the non-compete period, or some other mutually agreed upon consideration, which is not defined in the statute. And so that's been a nice, fun source of litigation. Other states have passed laws that basically said you cannot have a non-compete with an employee who makes below a certain salary threshold or a certain compensation threshold. So these are being heavily regulated. Generally, I would say you want to make sure that the restrictions are reasonable in time and place and scope. You can't have an overly broad non-compete. You really has to be focused on, for a reasonable period of time, generally a year is the most you can have in an employee non-compete. You want to make sure that the competition that's prohibited matches up with where this person actually did business, or that person actually worked for you, or where you actually do business within the world. You can't have a worldwide non-compete if you only do business in Massachusetts. And the type of competition, you can't say, say you have a, biotech company, and you can't say that, a researcher is prohibited from working for any biotech company, and then that somehow prohibits them from, going and working and doing something, sweeping the floors at a biotech company. It's just like, you can't. It has to be focused on the work that they were doing being competitive and somehow posing a threat to you, and being in your legitimate business interest to prevent that competition. You absolutely want to focus on what the employee currently does, and you want to be as narrow as possible in defining it. And I think that you will also need to balance it with the potential harm that it will do the employee, because that's what the court will do. So basically, you want it to be as narrow as possible to say, okay, what is the most? You don't want a non-compete to be so broad to say, okay, this gives me the most protection that I could possibly need, but leaves the employee without the ability to earn a living. You want it to be because the court's never going to enforce that. A court will enforce a non-compete, though, if it is narrowly tailored to protect your legitimate business interests, and it is reasonable, and the person is getting consideration for it. So I find that in cases where I've had to fight in court to enforce non-competes, it is where employers have been reasonable in drafting theirs that a court is more likely to enforce it than where employers have shot for the sun, the moon, and the stars and wanted the most broad non-compete possible.
So if you work for Coca-Cola and your job is to guard the secret formula for Coca-Cola, which is a famous trade secret, right? Coca-Cola cannot say to you, you can never go work for another consumer company in any capacity, right? They might be able to say to you, you can't go work for PepsiCo and come up with new formulations of new flavors of Pepsi.
Mm-hmm.
So then coming back to our rubric and putting on I'm a new founder working for subject to restrictive covenant agreements with my current employer. I mean, this is something you want to keep in mind as well. You might be working here in Massachusetts, and it's very unlikely that I think most folks who live in California and work for California companies, that's a very well-known prohibition on post-employment non-competes. But if you're here in Massachusetts, I can imagine a world where you are actually subject to a non-compete that may not be enforceable, or maybe of questionable enforceability, or there might be a question as to whether your current employer would bother to enforce it, right? So that's a question we get a lot with new entrepreneurs is, hey, I'm subject to this non-compete. I work for, a biotech company that's, working on this target disease indication. I want to jump ship and go work for this other biotech company that's working on a different target or using a different, scientific mode of action. And we have to help them, navigate the risk there. So Chris mentioned, what is the legitimate interest of imposing any of these restrictions, non-competes, non-solicits, and so forth? A lot of it goes to protection of the secret sauce, like I said, trade secrets.
Mm-hmm.
Neither Chris nor I are intellectual property lawyers, despite the title of this. This is really more of a startup presentation and an employment law presentation rather than a nuts and bolts of intellectual property presentation. What is a patent? What is patentable? What makes a highly defensible trademark and all the rest? There are other experts and other presentations for that, but just I'll leave you to peruse this list of basic elements of a trade secret, right? And just consider, trade secrets by contrast to patents, right? So trade secrets are forever, like the recipe to Coke, Google's search algorithm. Those are famously not patented bits of highly valuable IP, valuable beyond your wildest dreams, but not patented. Those companies, those inventors have decided that to forego the limited duration of exclusivity that patent rights give you as the quid pro quo for that is the government says, okay, we're going to give you 20 years of exclusivity to practice this patent and sell your drug. But you have to file something with the United States Patent and Trademark Office that gives everybody in the world the roadmap to tell them how to do this thing. And when 20 years is up, everybody can go ahead and do that thing. That's generic drugs, right? Companies like most software companies and famously Google and Coca-Cola have decided, no, I don't want to do this for 20 years. I want to protect this information forever. And obviously some things are not patentable. Customer lists are obviously not patentable. Marketing plans, except for very, very narrow circumstances, which may not even be applicable anymore, not patentable. So all this secret sauce that's under the hood of a successful organization, trade secret is an important part of the intellectual property protection strategy of most businesses. And I can let you read that. Yeah, question.
Oh, it's a quick question on.
Oh, get the live mic. Sorry.
Yeah, just a quick question about protecting your secret sauce and when you don't want to go down the patent route. Is there general recommendations as far as how to protect that from, for example, like Google's search engine or in that realm?
There are.
Okay.
Yeah. So let's go here.
Yeah.
So, physical security is obviously a obvious one. You can't just leave the recipe for Coke lying out on the desk and expect that that's going to be respected as a trade secret.
Absolutely.
Yeah.
You can't, you 100% cannot be lax in how you treat this stuff. Physically, you want to make sure you have appropriate electronic security over this data. I can't tell you how many times I've had clients, I've had to tell them that we do not have a viable misappropriation of trade secrets claim because they didn't take adequate steps to protect the confidentiality of their information. You want to, yeah. Sorry,
Digital, right, is the extension of physical, right? So digital security, limiting digital access to certain things.
Right. Like, can anyone find something on a server? Right. If anyone in your company could go onto your server and get access to it, and this happens quite a bit in. Oh, sorry, I leaned in.
Get closer to the mic.
Yeah, I will lean in like this. This happens quite a bit in startups. I find you go from an environment where you are at a skeleton crew where everyone needs to have access to everything because everyone is doing everything, but at a certain point, that no longer becomes true and companies don't adapt to that. And at a certain point, you have to adapt to that because otherwise you have to start asking, does everyone need to have access to this data that we hold to be confidential information that we consider to be a trade secret? Because if you don't, then you're going to lose that protection.
So we hit physical, digital, and I would say also practical. So you're going to trade secret protection policies, right? Where you talk about who has access to what, but also contractual. So this slide goes a bit to contractual. So if you are raising money, right, from venture capitalists, and to the extent that you need to disclose some trade secret to them, you can get real. Obviously the baseline is to have a non-disclosure agreement that you cannot disclose trade secrets except under NDA and expect that trade secret is going to remain respected as such, right? This gets a little tricky because most venture capitalists are never going to sign an NDA. They just don't, because otherwise they'd spend their whole life looking over their shoulder, because they need to comply with 1 million NDAs. They see 1 million pitch decks from 1 million founders. And if a founder puts an NDA in front of them, that's, A, it's going to make you look like you're not very sophisticated. And B, it's going to make you, their pitch deck is going to slide off the desk into the recycling bin. But there are exceptions to that, right? Especially in the biotech space, right? If take a real world example, I've got a client that has a diagnostics technology, very secret. I can't tell you what it is. But they have a big pharma partner. Investor came in, and they care a lot about knowing a little bit about this big pharma partner, the terms of the deal, who it is, what the pricing is, what the technology is, et cetera. We can't tell them that and maintain it as a trade secret and keep our relationship with big pharma partner a healthy one. So we set up, you can set up clean room agreements or lawyer's eyes only agreements, right? So I've been in situations where an investor who is writing the check to my client does not actually see the agreement, but rather I go and sit in a room with the lawyer from the other law firm. It's very like James Bond sort of stuff. It's sort of the most exciting thing we do, but
Very appropriate for you, Patrick.
The person who holds the trade secret will say, all right, here's the agreement that the recipient needs to sign. Here are the limited number of folks at their organization, and maybe it's just their lawyers who can see it. Here's how long they can have one printed copy of it. And when you're done with it, bring that printed copy back to me. You lawyers certify its destruction, or you actually give it back. So it's kind of like there's no magic bullet, but there's kind of just this like boring, do the work sort of stuff to keep track of. But we draft sophisticated trademark protection policies and procedures for folks.
Yeah, protecting trade secrets is big part of our practice, and we draft policies quite regularly to make sure that and audit and review employer practices to make sure they're doing the right things, to make sure that they have those things in place.
I've got the question there, but one more thing on this one, just thinking of our rubric of multiple hats. When you're bringing new people into your organization, you really want to make sure that your contracts say, hey, I'm running Newco Beverage Co. I'm hiring you from Coca-Cola. You better not bring any trade secrets from Coca-Cola, because I don't want to be getting a demand letter from Simpson Thatcher. Yeah. We have 5 minutes left, so we're going to try to.
Okay. Yeah. It's very interesting conversation. I have many questions, but I'll choose one. The one that I'm more curious about. So let's say I have an idea, a startup, but I also before the startup can start, I want to take time to evolve the idea, and I find a job, and I get a job. But the idea is different. It does not compete directly with the new job, but I still want to develop the idea. Is there any restriction that I have to consider? Or
absolutely, yeah, definitely there are. So you're going to look at the contract from your new employer, and it's going to say the only business, you are going to dedicate 100% of your business effort to Amazon, unless you get permission to do otherwise. And then in your proprietary information invention assignment agreement, say everything you do, every idea in your head belongs to Amazon for so long as you're working for us, except as set forth on Schedule A. So at the outset of your employment is your opportunity to raise this with your new employer and say, hey, I've got this vintage fly fishing gear business off to the side. I've got this website. Doesn't have anything to do with the biotech, the oncology drug that I'm developing for you, but I want to keep doing it. And usually employers will be reasonable in saying, yeah, that's fine. You can do that for, not using any company resources, not using any of your ordinary working time. And as long as it doesn't, involve any confidential information of the company or get into our field of interest, we'll carve that out. I mean, in practice, Chris, probably, people take risks and they do this sort of under the cover of darkness.
They do.
Right.
Yeah. And I think that, taking steps like this are really important. I mean, looking out for suspicious activity is number one, having your eyes and ears open, making sure you have people who are managing your employees, having their ears to the ground is very important. And making sure you have you're regularly monitoring your systems is important as well. You know, if you see somebody has, you know, suspicious activity, like somebody emailing themselves a huge swath of documents, or somebody downloading a huge amount of documents in one day. I mean, that's a huge red flag. And so you want to make sure you have certain measures in place, you know, whether through IT or others, that are going to alert you to these types of issues. But you're right. People do these things in the cover of darkness. You're not always going to find out. And I think that a lot of my clients are always kicking themselves, saying, "Oh, I should have seen this I should have seen this." You can have measures in place to try and detect this stuff, but you're not always going to find that out, unfortunately.
I think we're at time.
Yeah. Any more? Yeah.
Are unfortunately at time. Patrick and Chris, thank you so much. Love to give you a round of applause. Thanks for being here.
Thank you.
And folks, we have a lot more in store for today. We do have our closing party and our startup showcase tonight at 5 p.m. here at Suffolk. So if you are an early stage founder and you're interested in getting your product or your organization in front of hundreds of folks tonight, I do believe that there are still some slots available. The catch to that is that you do have to head down to our welcome desk on the first floor to sign up for a free table for this evening. Again, thank you so much to Suffolk for hosting. And in this room next, we have a tale of two departments: who owns customer expansion. So if you want to stick around for that, please do. If you want to catch up with our fantastic speakers, if I could ask you to do so outside of the room, that would be great. Thank you so much. And again, see you tonight at the closing party at 5 p.m. Thanks.
Thank you so much.
Thank you so much. It's a pleasure to have you.
Oh no, thank you for having us. Nice to meet you. Be able to get here.
I know. I'm sorry that
No.
It's a great place for access.
No. It was my fault. Like, I should have planned. What I should have done was I should have parked at our office and Ubered over out in here. I should have planned.
Thank you for the great.
Oh no, thank you. Thank you for the questions. I appreciate it.
Try to reach